Do social media companies engage in censorship when they moderate content on their news feeds? The states of Texas and Florida think so, and so they passed laws forbidding or otherwise penalizing this practice in one form or another. Of course, the social media companies disagreed, and with good reason. So they sued for an injunction to block the laws, and the case rose to the level of the Supreme Court, where they asked to strike down the laws on the grounds that they compel speech and so violate the First Amendment. Are they correct? That is a question we will discuss on today's New Ideal podcast, the podcast of the Ayn Rand Institute. Welcome. I'm Ben Baer, fellow and instructor at the Ayn Rand Institute. With me is Paul Taske. Paul is associate director for the litigation center at NetChoice, which is one of the parties in this recent Supreme Court case. He specializes in litigation that's related to the First Amendment. Before joining NetChoice, he clerked for justice at the Ohio Supreme Court, and more importantly, for our purposes, before that, he was a junior fellow right here at the Ayn Rand Institute. Paul, really great to have you today.
Great to be here, Ben.
So, Paul, we're actually discussing two cases, separate cases that were joined together in the court's decision. One of them is Moody v. NetChoice. This is the one that concerned the Florida law. That law was the one that prohibited social media platforms from banning political officials and from engaging in other kinds of content moderation. Then there's also NetChoice v. Paxton. This is the one about the Texas law, which prohibited platforms from quote-unquote censoring user speech by suppressing posts through the operation of certain algorithms. And NetChoice, your organization, is a trade association that represents the different technological companies who are impacted by this decision. They're the ones who first filed for the injunction and then moved for the court to overturn these cases. What happened was that the 11th Circuit of the federal court system, they affirmed that injunction. That's the Florida case. The Fifth Circuit denied the injunction, so we had a split circuit. And very often when there is a split circuit decision, that's when the Supreme Court is asked to weigh in. So, Paul, first, tell me if I have the basic facts of that right. And then second, how would you summarize the basic question that was brought to the court and that they thought they were answering, especially by putting these two cases together?
Yeah, so those basic facts are spot on. We have two cases, as you mentioned, and I think the court was really trying to answer the question of whether or not social media companies have First Amendment rights when they moderate content, and that includes when they remove accounts, when they deprioritize posts, when they curate posts to appear in a certain way before users, when you're just scrolling through Facebook, when you are reviewing comments on Etsy or what have you. And I think the court was really trying to answer that question. And so it made sense for them to take up both cases at once, because you did, as you mentioned, have a split between two circuit courts of appeal. So that means the rules were different for two swaths of the country. In Florida and the neighboring states, social media companies enjoyed First Amendment rights because the 11th Circuit, in our view, correctly held that these are protected editorial choices made by these companies. And then in the Fifth Circuit, they ruled that this is not First Amendment protected speech. It is, to use the Fifth Circuit's term, censorship. And so the court was asked to resolve that split, that issue. And so we got that answer, and eventually, and the majority of the court said that yes, they were comfortable with our arguments and the conclusion that, as we argued them, these things did involve First Amendment protected speech. And so on remand, the lower courts need to look at things similar to how the 11th Circuit addressed them in the Florida case and chastise the Fifth Circuit for its approach.
So let's clarify a few things maybe for our viewers who are not so familiar with the workings of the federal court system. What exactly does it mean that the Supreme Court has, first of all, vacated these circuit decisions and remanded it back to the lower district courts? What does that mean, especially in practical terms, for whether these laws are actually going to go into effect?
Sure. So the decisions of the Fifth and 11th Circuits were vacated, which means that the court basically wiped them away. They are no longer binding law in those circuits. And the court then remanded them for further consideration by actually the circuit courts in the first instance, the Fifth and 11th Circuits. So on August 2nd, NetChoice filed for supplemental briefing in the 11th and 5th Circuits to address the Supreme Court's recent decision and try to alleviate some of the concerns and questions that the court was raising, and said that the circuit courts needed to consider more fully on remand.
And why is it exactly that the Supreme Court only vacated and remanded? They didn't want, it seems, to rule on the merits of the case that was actually brought before them. They certainly didn't seem to want to vote to overturn any laws themselves just yet. Can you say more about their reasoning there?
Sure. So I think it's pretty clear that the court agreed with our view of the laws in terms of how they were argued and presented. We argued that these laws really targeted the core heartland aspects of social media companies. That's what Texas and Florida both were, trumpeting their laws as applying to. And so obviously we thought that those were unconstitutional applications. The court raised some interesting questions about, well, do these same sorts of restrictions affect First Amendment concerns on other platforms as well? Something like Uber's Uber service or Venmo or some others. And so they wanted a little bit more development before they officially ruled, but they did go out of their way to say that, insofar as the 11th Circuit looked at these issues, the 11th Circuit got it basically right. The First Amendment applies in the way to protect content moderation decisions that are made by these companies. And the Fifth Circuit was off base when it said that these types of laws don't get First Amendment protection.
Now, when you speak of the court, what I take it you mean is you're referring to the majority of the court, the one that wrote the majority decision. And just for the record, we're talking here about the three liberal justices, Kagan, Sotomayor, and Jackson, joined by Justices Kavanaugh and Justice Barrett. There were, however, four of them left over who didn't concur with the majority reasoning. They agreed with the decision, the outcome of vacating and remanding it, but they didn't agree with the reasoning. And so even though there was a unanimous opinion to vacate and remand, we got two concurrences written by Justices Thomas and Alito where there's significant disagreement with the position taken by the majority. And that, I think, is one of the more interesting things to talk about, the nature of that disagreement. And so if I got that right, could you summarize and explain to our audience what is the basic nature of the disagreement that emerged between the majority decision and the concurrences?
Yeah, I'll just note that Chief Justice Roberts was also on our side. He also
Yes.
concurred in the majority opinion. He thought that was the correct way to go about this. But the core of the disagreement, I would say, between the majority opinion and at least the Alito concurrence, is the majority thought that there was enough information to go on to say, yes, at least as applied to the core functions of social media, so the Facebook news feed, the YouTube homepage, these laws would be unconstitutional. And we think the 11th Circuit got that right. We think the 5th Circuit got that wrong. Justice Alito's concurrence wanted at least a lot more information before he was comfortable making that sort of determination, and he seemed somewhat skeptical. So, if and when these cases make their way back to the court, we would obviously have our work cut out for us to persuade Justice Alito, but we're confident that we could do that, and we're confident that the more information the court has, the more sympathetic and more amenable they'll be to our position moving forward, even to some of the tertiary services and not just Facebook and YouTube.
Anything you want to say about Justice Thomas's concurrence?
So Justice Thomas's concurrence is definitely interesting. He regularly uses his separate opinions, separate writings in cases like these to hypothesize and pontificate about interesting questions that he thinks the court should pay more attention to. He wrote a similar concurrence earlier this term in a separate case the Food and Drug Administration versus the Alliance for Hippocratic Medicine, where he similarly questioned whether facial challenges were appropriate, whether trade associations are the right vehicles to bring these kinds of challenges. But he hasn't always focused on issues like this. He's written separately on a number of different issues, including the protection afforded to commercial speech, whether or not free exercise should be, the free exercise clause of the First Amendment should be applied to the states. And often he does this writing alone. You notice in his separate concurrence here, no other justice joined him. So while they're interesting to read, I don't know how informative they are for how the law is looking to move in the future.
I do want to come back to what he says about facial challenges later in our conversation, perhaps, because I think there's an interesting issue there, and we'll explain to the audience what that means. Before we do that, though, I do want to get to the more, I want to start with the really substantive questions. And one of the things that I find so interesting about this case, and especially about NetChoice's position on this issue, is NetChoice is unambiguous, and sometimes to the consternation of the justices, you especially hear this in the oral arguments, you're unambiguous that content moderation policies on a platform, in other words, the platform's exercise of its editorial judgment about what, for example, will appear in a newsfeed, moderation, which may even include suppressing posts, sometimes even deplatforming users, you're unambiguous. This is not censorship. And it doesn't even make sense to call it so-called private censorship, a certain subtype of censorship. You're unambiguous that the First Amendment protects against government policy. And that's what censorship is. Censorship is a form of state-sponsored forceful suppression of speech. So tell us more about the stance that NetChoice has taken on this and some of the reasons for that stance.
So NetChoice is a trade association that takes certain ideological positions. We have a mission that we believe very strongly in, and that mission is to keep the internet safe for free expression and free enterprise. And those things are really corollary positions for us. And so, at least on the free expression position, that means that we take the First Amendment seriously when it says that Congress shall make no law abridging the freedom of speech. And so the First Amendment protects individuals, companies, groups to be able to express themselves and convey ideas, or to, govern how their publications or services convey those ideas. And it protects them against the government. So the government can't come in and mandate what you can say or how you can say it or what you have to publish or what you can't publish. And so Florida and Texas stepping in and saying, Facebook, YouTube, and all of you social media companies, you have to, allow this content on your service in the way that we think is the most appropriate. That, to us, fundamentally violates the First Amendment, and we have legions of cases to sort of back that up, which makes arguing the law really easy for us when we can point to prior cases saying, hey, the government isn't allowed to do these things, and the court has said so in a number of other contexts. But then I think it's also important to reference that these laws support our other position as well, free enterprise, because if the government is able to come in and regulate how content moderation works, it really eliminates any sort of competitive desire to, compete on how and what content you moderate and how you moderate it. I mean, we've seen in just the last couple of years with Elon Musk's takeover of Twitter and rebranding of it as X, that they have implemented different content moderation policies, including the use of community notes to sort of ferret out some misleading posts on the platform. But if Texas and Florida had their way, that sort of innovation would really stop. And so you have a bunch of other, smaller companies that sort of innovate in this way. Reddit, for example, moderates content through users, and the users primarily drive how content is moderated on those services. And so we want to see that sort of innovation and competition thrive in this space as well.
Yeah, I think it's a really important stance. And I would just add, from my perspective, that it's not just an issue of how is free speech spoken of in the First Amendment. It's like there's a question about the actual objective meaning of the concept of censorship. And yeah, people can use that term loosely. to talk about public censorship versus private censorship. But when you group when you group the phenomena of both private actions and government actions together under the heading of the single concept, you have, I think, what Ayn Rand would call a package deal. You have grouping by superficial similarities in spite of really fundamental differences. And there's a basic fundamental difference between private action, which is the realm of the voluntary, the realm of rational persuasion, and government action, which is in effect the operation of force. So it's really important to keep these concepts clearly defined and to separate those two fundamental issues. Censorship is a concept for talking about certain kinds of government action, which doesn't mean that government's the only entity that can violate First Amendment rights. You can also have private people trying to shut down the expressive activity of other private people, but that's a broader category.
Yeah, I think
So
that's fundamentally right. We want to clarify and make sure that people understand that what Facebook and YouTube are doing when they're moderating content in this way is very similar to the choices that are made by outlets like the New York Times or the Washington Post when they are prioritizing certain stories. If something is put on page one above the fold, they're obviously placing a greater weight and value to, making sure that readers see something rather than burying it in the middle of the paper in a smaller section, or even just choosing not to run certain stories or choosing to, run multiple of stories from different perspectives. It's very similar to what happens on social media companies' services when they are moderating their own content. And so, drawing those similarities, I think, is helpful because you wouldn't say that the New York Times is censoring me if they refuse to run my wedding announcement. They didn't see a value in running that. Similarly, Facebook and YouTube and all these other platforms are making value judgments about what is desirable to see on their service, and they're making those choices daily.
Yeah, for some reason I couldn't get my wedding into the Times either. Uh, but let's explore that. Let's explore that a little further, because one of the arguments that comes up between the majority opinion and the concurrences is precisely about that comparison you just made to the editorial judgment of a newspaper. The majority seems to agree with NetChoice's argument here, that there is a basic similarity, but the minority is more skeptical. They think that free speech protection, First Amendment protection, only applies when a company is engaged in essentially expressive activity. Editorial judgment is a sign that there's expressive activity going on, and but they think that there are differences between what's happening, say, in a social media platform's a news feed, the use of algorithms to cultivate that, to curate that, and what a kind of old school newspaper editor is doing. Can you sum up for us what the disagreement, the nature of the disagreement is there, and how you would respond to it?
Yeah, so I think the disagreement there comes down to the issue of familiarity. Um, new technologies have regularly been somewhat difficult for the court to address, especially in the First Amendment context when assessing whether or not something qualifies for First Amendment protection. It's actually funny if you go back to some of the earlier First Amendment cases, you'll see that when the court was first confronted with the question of whether or not movies count as First Amendment protected speech, they said no, they don't. Um, and movies at the time were relatively new. This happened, I think, in 1915, so they'd only been out for about a decade or so. They've since reevaluated that position and said that movies are clearly expressive, clearly engaged in sort of the conveyance of ideas in the way that we're all familiar with today. But at the time, they were new, and I think that is somewhat reflected in the hesitancy that you're seeing from some of the concurrences to analogize what social media is doing to what the newspapers do. It's a lack of familiarity with how social media operates, but really they operate in fundamental terms, they operate in the same way. And in order to do that at scale, they implement algorithms to do a lot of the sorting for them. But those algorithms are, of course, programmed and instilled with the value judgments that the people, directing the content moderation policies at these companies, think are the right way to go. And so I think as the court becomes more familiar with social media, with AI, with all of these different new and emerging tools, there'll be less of a reluctance or a hesitancy about, making those sorts of analogies to things like newspapers, movies, and other, now widely recognized expressive activities.
Yeah, the conversation about the use of algorithms in the oral arguments I thought was particularly curious. It's the critics from the minority asking about the use of algorithms seem to have the view that because they're algorithms, because they're run by computers, it's as if there's no editorial judgment that's exercised in crafting those algorithms in the first place. And your attorney is quite insistent. Well, obviously there is. These are algorithms that are crafted by people and with certain kinds of priorities, such as community guidelines, in mind, and that doesn't seem to budge the minority's opinion. I'm not quite sure why. Obviously, tools are used by people. But there is this other issue that comes up in that same conversation. One of the reasons the minority is skeptical that it is essentially expressive is because they argue that, well, with so many different messages from so many different people, from so many different perspectives on a news feed, that it's unclear what is being expressed. The idea here is there needs to be some kind of specific, consistent message conveyed for it to be an expressive activity. And how does NetChoice respond to that kind of argument?
I mean, I think the court has been fairly clear in the past, and NetChoice certainly agrees with this, that you don't have to have any sort of inherently consistent message, that, or at least not one that would necessarily be understandable to someone as an outside observer. There have been past cases. The parade organizers in Hurley were curating, and they wanted to deny access to the parade for the LGBT contingent of the Boston Irish parade, even though they were Boston Irish LGBTQ individuals. And that case, believe it or not, made it all the way up to the Supreme Court. And the court said, yeah, there are a lot of different voices here in the parade. They have, the Black Irish, they have, all of these other different groups. And so there might be something that might not look like a coherent message, but their message is one of exclusion. They say, we don't want to be associated with this particular message. Whether or not the messages they want to be associated with would be understandable to you or me as an outside observer isn't relevant. What they're doing is exercising their choice over the things that they deem acceptable to be associated with. And so similarly, in the social media context, even if most of the content is permitted on the service, the core question is, well, what are they excluding? Do they think that they're excluding something that isn't valuable for their service? And they're making those choices. And so it doesn't have to be clearly articulable, consistent messaging. I mean, you wouldn't make an argument that the New York Times doesn't receive First Amendment protected speech rights because they allow opinion articles to be published from competing viewpoints. It's never necessary, at least in my view, that something be entirely consistent and understandable to an outside observer to qualify for First Amendment protection.
Yeah, the comparison I like here, especially, I think it comes up at one point in oral arguments, is a bookstore. I mean, you could maybe reasonably argue, well, the New York Times is only a very small number of articles per issue, but like, how about a bookstore where the owner has the right to not sell certain books that he finds particularly offensive, but the ones that he is selling, there's quite a lot of them in the whole store with lots of different messages on lots of different subjects competing with each other. You wouldn't take from that fact that therefore he doesn't have a First Amendment right to decide what is sold in his store. And I think one of the other arguments that comes up that I find fairly persuasive is that if there's any message here, it's that we find this range of opinions worthy of consideration, even though it's a range of opinions. And that includes then saying some of them we don't find worthy of consideration. That's why we're not including them. But there's an assumption still lying beneath that whole debate, that in order to qualify for First Amendment protection, it needs to be expressive activity in the first place. And I think we should talk a little bit more about that. I know that there's a precedent that's cited in that regard, the Miami Herald versus Tornillo case. That's the one that about a newspaper. And I'm just curious to hear what you would say in response to this question. Doesn't the First Amendment protect more than just actual expression? Because free speech includes the right to not engage in this expression of any kind, if you so choose. It's the right to speak and the right not to speak. And so even if just for the sake of argument, we said that the social media platforms weren't engaging in any kind of expression, but they think that if certain kinds of viewpoints or certain kinds of discussions that if they became included in that news feed, it would be sending a message. Isn't it still their right to say, well, we don't want to risk sending that message. That's our right not to speak. And therefore, the First Amendment would still protect it, even if it weren't essentially expressive. It wasn't essentially expressive yet, and they're trying to make it not be so. Do you have any thoughts on that?
Yeah, I think that's largely correct. I definitely agree that the First Amendment protects the right not to speak, and so that involves, not being compelled to carry certain messages, whether those messages are themselves like inherently expressive. You can't be compelled to recite the Pledge of Allegiance, for example, is one of the most famous examples in all of constitutional law. But so I'm not sure how the court would look at that in this particular context, but I think it's right to say that, you have the right not to speak. And even if you view this as not expressing a coherent viewpoint, you still have the right not to express a coherent viewpoint. So again, the choices about content moderation really boil down to these are still First Amendment protected activities, and it's essentially the thing about you don't have to use your First Amendment rights not to lose your First Amendment rights. The First Amendment rights aren't contingent upon exercising them in a particular way. You still have them regardless of how or whether you choose to moderate content.
What, to me at least, seems to especially add insult to injury, what it is about these state laws that adds insult to injury, and any sympathy for the state laws coming from the minority, is that one of the things the state laws require is for when social media platforms do suppress certain kinds of posts or remove them or deplatform people, it compels them to provide reasons. And it also compels them to basically reveal the content of the algorithms that they use in order to manage their platforms. And that's a clear case where they weren't expressing something before. They had good reason not to want to express it, not to reveal the content of their algorithm, et cetera. And now the law is actually forcing them to do it. Now, I suspect that they would have reasons for thinking this wasn't the kind of speech this wasn't the kind of compelled speech that the First Amendment protects against. But don't these laws also very explicitly compel speech by forcing disclosure of algorithms, by forcing disclosure of the reasons for deplatforming? And so it's a particularly egregious violation of the idea that free speech includes the right not to speak.
Yes, that is exactly right. By compelling sort of the revelation of why you've made certain actions, that is certainly compelled speech in terms of why you're removing certain users. But there are additional reasons why that is objectionable to the company's perspectives. I mean, if you have to provide individualized explanations as to why you've removed every single thing, you're providing essentially a roadmap for people to game the system. of course, there might be incentives to provide some general rules of the road, which the companies do through their terms of service. They want the people to know sort of the content that they will or won't be allowed to post, so that they sort of reduce the friction of people exercising, their own First Amendment rights on the service, speaking in ways that are not objectionable to the service and won't get them kicked out. But beyond that, I mean, there's no obligation on the service, and there's certainly no First Amendment obligation on them to provide anything in addition to what they're already doing.
So I want to come back to the issue that it came up with the Justice Thomas concurrence, but it's broader than just his concurrence. Something that everybody in this decision, majority and minority, seems to agree about is that NetChoice's case was particularly ambitious because it was, as they say in the business, a facial challenge, which means that you were arguing that these state laws violated the First Amendment on face, and that as such they should be struck down in whole as unconstitutional. And so, for Justice Thomas, he writes an argument saying there should never be any facial challenges. Everybody else thinks there can be, but that there's a high bar to meet them, for them to actually succeed. And so the question I have for you is, why did NetChoice choose to make such an ambitious argument? How would you defend it? And why, in effect, do you think that it's not enough to just challenge these laws as applied in certain cases? Why should they be struck down as such?
So, I mean, let me take a step back, just if I could briefly, and give a little bit more context about the standard here.
Sure.
So a facial challenge in most circumstances means that a law is unconstitutional in all its applications all of the time. That is what needs to be shown for most facial challenges. In the First Amendment context, the court has a still rigorous but slightly more relaxed standard, saying that you have to show that there are a substantial number of applications that are unconstitutional in relation to the law's, quote, plainly legitimate scope. A little bit of squishy language there to allow breathing space for First Amendment protected expression not to be, hamstrung by too stringent legal standards. And so we knew that was always going to be the standard we were operating under. It's been a consistent standard, and the court took the opportunity here to reiterate that standard. But we still think we can meet that standard. We think that the law is plainly unconstitutional in a substantial number of applications. And the court clearly agrees that it's unconstitutional as applied to Facebook and YouTube and their feeds. But we think that no matter where you're applying these laws, because they are restrictions on the way that content is moderated, curated, disseminated to others, you're still trying to restrict First Amendment protected speech and the editorial choices involved there. To take just one example that the court focused on at oral arguments, they wanted to know how a law like this would apply to a company like Uber. Uber doesn't have a traditional social media feed, but they do allow users and drivers to post comments, reviews, and other such, aspects of speech. And the issue, if you are to look at that law and if Uber is covered, the question isn't, well, is this law going to restrict Uber's ride-sharing function? It's how does the law apply to the editorial choices that Uber might be making in its comment section? So it might remove comments because they're vulgar or otherwise inflammatory for no reason, or they might prioritize certain comments. They think that this poster is a reliable source of information about the quality that you're going to receive from this restaurant or from this driver. And so those choices are editorial decisions made by the company. And so to the extent that these laws impact other companies, they're still going to restrict First Amendment protected speech. And so we think that it's clear, and we're happy and eager to make that showing to the court with further briefing, that these laws are substantially unconstitutional in regard to whatever plainly legitimate sweep they might have.
So related to that, one of the reasons for the skepticism about trying to make this a facial challenge is the minority points out, and I think if I remember correctly, even Justice Barrett joins them in this question in her concurrence, that there's a lot more to these social media companies than their news feeds. There are many different functions they perform. So if you're talking about a company like Alphabet that runs YouTube, well, they also run Google, they run Gmail, and so what about how would this law say, for example, apply to their management of Gmail? The skepticism here is if the law stopped them, say, from kicking people off their Gmail accounts or from stopping them from sending certain kinds of messages, that would not be on face unconstitutional. That's their view. And so therefore, there's a lot of things that these laws could be applied to that would not be unconstitutional. And therefore, it's not a good facial challenge. I know that NetChoice takes a different position on that question, even about Gmail. So could you share that with us and what you would say about that kind of argument?
Yeah, I think Justice Barrett is probably the most genuinely curious in her concurrence. She wants to know how these laws would apply to certain other aspects of these services. Um, and I think it was pretty clear during oral arguments that there was real frustration with the states for not having sort of a clear view of what their laws would cover. Um, we took the states at their words when they passed these laws that they applied to social media companies and sort of the heartland applications that were at the meat and, at the heart of the arguments we were making. Um, for how they would apply to things like Gmail, I mean, it might be a tougher question, but I would still say that Gmail certainly prioritizes and curates information for their users. I mean, one of the, defining features of Gmail, at least when it was released, and I think other providers have since sort of adopted this approach, is the sort of filter to your inbox, things that are primary that they think are going to be important to you versus things that are related only to, promotions that you're subscribed to, or social updates that might not be as relevant to you. They have that primary inbox for you, and those choices, that's how I think this would really apply to something like Gmail. And I think that those choices again would fall under the sort of protection of editorial discretion that the court reaffirmed apply to social media and to the internet more broadly in the NetChoice and the Moody case.
Yeah, and it's worth pointing out these are some of the things that make Gmail actually valuable to the users. The fact that it's curated in that way, especially against the spam, right? Um, though there's a broader question here because one of the things the minority seem to be particularly skeptical about is the idea you could kick people off of Gmail as such. And well, at least for my part, yeah, you don't have a right to a Gmail account. There's lots of different options if you don't get to have a Gmail account. But this then relates to one of the bigger issues, especially comes up in both, I think, Thomas and Alito in their concurrences. And that's part of their argument for why they think newsfeed curation is not expressive. And this goes hand in hand, I think, with their kind of algorithm argument. It's that it's just, in their view, transmitting information. It's just, quote unquote, dumb pipes. That's part of why it's not in any way essentially expressive. They then see these social media platforms as much more like telephone service, telegraph companies. To use the legal parlance, they should be deemed common carriers, so-called, and that then has different implications for whether they can receive free speech First Amendment protection. What's NetChoice's take on the common carrier argument?
Yeah, so I think, whatever you might think about common carrier as a doctrine, it's particularly an inapt comparison here. I mean, the whole purpose behind common carriers is that these people are making essentially no discrimination. They're taking all comers under any circumstances. If you can pay the fair rate, then you get on the train or the ferry or whatever. Your goods will get shipped from point A to point B, and there's nothing happening in between. But whatever you think of that, that's certainly what's not happening on social media. There are these algorithms, these choices, these designs that filter, that disseminate in particular orders ways that the companies think will be valuable and most relevant to their users. They're making those value judgments throughout the process for all the content that you will see for every user on the service. I mean, the analogy to dumb pipes is particularly inapt to me. I mean, we've talked a lot about newspapers and bookstores. A judge in a separate NetChoice case suing Ohio called them compilations of letters to the editor. It's still sort of that compilation, that putting together of information in useful ways that makes these services valuable to people. They're not just dumb pipes. I mean, we've strenuously argued against the idea of common carrier throughout this litigation. I mean, we have a strong view that it's particularly inapt here.
Yeah, you say, I think tactfully, whatever you think of the common carrier doctrine, and it's worth putting on the table what I think about it. It's highly, at least the very least, find it highly suspicious that there should be any such designation. And the reason that makes it plausible, I think, especially with telephones and telegraphs, is that these companies were at one time given a formal legal monopoly by the state, where nobody was allowed to compete with them. And so, having received that privilege, it came with certain costs, which is that they had to then take everybody, because there were no choices by legal mandate that you could go to as alternatives. But that's clearly not the case when we're talking about internet companies. There's dozens, if not hundreds, of competing alternatives. There is no legal franchise awarded to any company yet. It's an interesting question what will happen if these regulations go into effect and only certain companies are able to afford the price of the regulations. You might end up having a kind of de facto franchise, but we should prevent that from happening. As arguably it should have been prevented in the case with telephones and telegraphs. But I want to move on to another kind of a more procedural issue that I think has some significant philosophical import to it, and that is this issue of judging cases on grounds of strict versus intermediate scrutiny. As I understand it, and again, correct me if I'm not getting the context right here, the doctrine here is that strict scrutiny cases are the ones where there's a kind of, in effect, a kind of judicial veto power that courts have against certain kinds of government action, where there's this just direct and blatant and obvious violation against a certain kind of cherished right, like a First Amendment right. And so you subject a case to strict scrutiny where it involves one of those possible violations. But in other kinds of cases, the so-called intermediate scrutiny kinds of cases, if there's an alleged infraction or violation, or where you're seeking a certain grievance, the demerits of that grievance need to be weighed against, in a sort of utilitarian kind of way, against the compelling government interest. Here, in this case, the majority, as I understand them, is saying, even if you do this on intermediate scrutiny as opposed to strict scrutiny grounds, they say even on that weaker standard, the Texas law still fails. They simply don't see that there's any compelling government interest in creating a balance of ideas, which is Texas's stated justification for their law. And the only interest they say government has in creating a balance of ideas is by prohibiting government from tilting the balance by means of the First Amendment. Now, the minority seems to disagree with that, or at least take the state's objection to it a little more seriously, that there could be some kind of legitimate government interest here, and that encouraging a variety of ideas on a platform just is one of them. it sounds to me a bit like a tastes great, less filling debate. It's just a yes or no. How do we weigh these competing contradictory assertions?
I mean, I think it's hard to give credence to the competing assertion that there's a government interest in protecting sort of a balance of ideas. I think the whole, the good thing about the idea behind the marketplace analogy is that it operates without government involvement. The best ideas will kind of rise to the top, and people will engage with them more versus ideas that are less popular will sort of sink into the background, and it doesn't need the government to get involved. These things have a way of sort of almost naturally working themselves out. I think the majority here is really right in saying that the government has no interest in sort of getting involved and tipping that balance one way or the other, and Texas has can't rely on that as a justification for its law. We were heartened to see that in Justice Kagan's majority opinion. We think that's exactly right here in the First Amendment context, and we're excited to sort of see that play out as the cases are remanded.
And for my part, at least, I find the whole doctrine of strict versus intermediate scrutiny to be questionable at the very least. That there could be government interests apart from the ones that are mentioned in context of strict scrutiny. It strikes me that if you take seriously that the Constitution is a charter of powers for the government, then the only quote unquote interests it has are exercising those powers, and all of those powers are directed toward one and only one interest, which is the protection of the rights of the citizens. So unless there's a right to a balance of ideas, that it just doesn't come up. But let's talk
and I think
a little more.
I think that's right in the. Oh, sorry. I was just going to
go
say,
ahead.
I think that's exactly right in the First Amendment context. As I mentioned earlier in the episode, the First Amendment is structured in a way to protect the individual from the government. That means that the government must not be involved in the marketplace of ideas, in sort of shifting what the balance of ideas in the marketplace are, even if it's lopsided and one set of ideas seems to be more popular. The government can't get involved so long as that's sort of the result of private action. The government's one responsibility there is to step in when, say, other governments are stepping on the toes of people's First Amendment rights. It's entirely incumbent on the government to defend people's First Amendment rights, not encourage certain people's rights over others and sort of play favorites in that way.
So one of the last few questions I want to ask is about Justice Thomas's concurrence, and you mentioned before that he typically likes to write these kinds of lone concurrences where he pontificates on a favorite point of theory or procedure, and here it's his view that the very idea of a facial challenge is somehow unconstitutional, that he thinks if the court takes upon itself or arrogates to itself the power to strike down entire laws, that first of all, this is a violation of the Cases and Controversies Clause of Article 3 of the Constitution, that says the court may only hear cases concerning cases and controversies between various particular parties. But what a facial challenge is one party coming forward to say this whole law should be overturned, and even when it will affect countless other cases of people who are not before the court. And so his objection to that is that it would in effect impinge upon the separation of powers, because it would give the courts this sort of undue power to override democratically elected legislatures. Alito doesn't agree with him, but he at least sounds skeptical about facial challenges for the same kind of reason. Now, this wasn't discussed much in the oral arguments. It is right there in the concurrences, though. Does NetChoice have a view on the Justice Thomas's view here about the illegitimate nature of facial challenges as such? I mean, I imagine you must, because you're making one.
I mean, we've made facial challenges, not just here, but in our other cases. NetChoice has a slew of other cases that we're managing, related to challenges to various age verification and parental consent requirements for accessing social media. And we've made facial challenges there where we think it's appropriate. We certainly think that facial challenges are permissible, and I mean, until the court tells us definitively that they're not, we'll likely continue to raise them where we think appropriate. We obviously appreciate Justice Thomas's thoughtful writing on this issue, because a lot of one-man concurrences can become the norm later. So it'll be interesting to see what happens. But I mean, at least from my perspective, I think that facial challenges are permissible in certain circumstances that the court has already defined and delineated for the last century, essentially. But I'll be interested to see how this area of the law develops, and if this idea sort of gains more traction.
And just to follow up on that a little bit, do you have some sense of how Justice Thomas or anyone who shares his view would respond to this kind of question? Are you telling us that if Brown v. Board of Education happens, a single individual comes forward to say Jim Crow laws are unconstitutional, should be struck down, that he's going to say, well, we can only judge case by case. And so we're going to say this law as applied to you as an individual is unjust, so you should be exempt from it. But before we strike down the whole law, we have to see every other case of every other individual who's affected by it. Is there a response to that kind of counterexample?
I'm not sure how Justice Thomas would respond to that. I really couldn't say. And again, I mean, he's writing for himself here, so I'm not sure that there's widespread agreement on this issue. But you'd really have to ask him.
If I ever get the chance, I will. It strikes me that the part of the role of a court, at least of the Supreme Court, is to review laws for their constitutionality. And if a law as such is unconstitutional, of course, it comes up in the form of cases that relate to particular parties, but it's the law that is in question in those cases. That's at least my view of the subject.
One last is generally right about how cases emerge. Cases and controversies really sort of stem from the idea that courts can't issue advisory opinions. The legislature can't just go to the court and say, hey, is what we just did unconstitutional, without any sort of developments. But when individuals who will be affected by the law or their representatives, so NetChoice is a trade association for certain companies, bring this to the attention of courts saying, hey, this will unconstitutionally affect our rights. I mean, I think it's right. And I think the court has been in large agreement with this, that it is the role of the judiciary to address the constitutional concerns raised by the parties.
You just mentioned the issue of advisory opinions, and that connects to my last question, because although the majority did vacate and remand this, send this back to fulfill certain requirements they wanted to see in a proper challenge of this nature, they also weighed in, very explicitly, as you've mentioned several times, on especially the Fifth Circuit's decision and how they thought it was just way out of line with regard to First Amendment jurisprudence. They seemed to be skeptical that the Texas law in particular would survive a facial challenge. But the minority opinion calls them out for weighing in on this, saying that if this is really just a vacating and remanding, that in fact the majority shouldn't be weighing in this way. And so can you shed some light on what's going on here? What are they doing? Is there a reason that the minority has to object to what they're doing? And what is NetChoice's view here?
I think this goes back to something that I mentioned earlier, that it really stems from difference of opinion about the level of confidence they have in whether certain applications, the ones at the heart of our challenge to the Supreme Court about the standard things related to social media, the news feeds, the home pages, are constitutionally protected. And obviously, the majority thinks that they are. And so I think the majority was trying to sort of avoid an immediate repeat of the problem out of the Fifth Circuit by letting the Fifth Circuit know that we want you to do this analysis. And when you do that analysis, know that the thing you did before was not correct. And so you need to look at it differently in the way that we're outlining for you here. And so not only when you're looking at those issues again, but also when you're looking at the new issues that we're sort of flagging, raising about new applications for this law, take this in mind. This is what we're concerned with, and we need you to apply the First Amendment in the way that it does and should apply. And if you need guidance, they said the 11th Circuit sees it largely as we do, and so the 11th Circuit, had the benefit of knowing that it, to the extent it analyzed the relevant First Amendment questions, did so correctly. I think the court was perfectly fine to issue that guidance in the way that it did, and we were very thankful to see such a thorough understanding of the First Amendment, how it applies, and a commendation for the 11th Circuit saying good job, and sort of repudiating the Fifth Circuit's out there approach to how the First Amendment applies.
Yeah, I was happy to see it too. I was especially happy to see it coming from both liberal and conservative judges. It's worth noting, I think, that even the Fifth Circuit's opinion was a split decision, and so I think just barely the majority ruled in favor of that seemingly mistaken view. So, Paul, this has been a really great conversation. I think you've shed a lot of light on an important case, and I'm sure we're going to have you back, because this is probably going to go back to the Supreme Court. We're going to get a more definitive decision from them that's going to have some probably long-term implications for the state of online free speech. And the title of this episode we put as "Online Free Speech on the Brink." Hopefully, at least in my view, will be pushed back from the brink, and we will continue to have it. I wanted to share some resources with our viewers so they can learn a little bit more about some of the topics we discussed. First of all, we have a book recently published by the Ayn Rand Institute Press, the First Amendment. This is edited by Tara Smith, and there's a one chapter in this book by Greg Salmieri, who's a friend of the Institute, called "Free Speech as a Right and a Way of Life," which you can read now online on our online publication, New Ideal, if you go to bit.ly/free speech way of life. And this takes on many of the subjects that we talked about in our conversation today. First of all, outlining the philosophical foundations of what the right to free speech is, what it isn't, weighing in on what is and isn't censorship, what is and isn't covered by that concept. And there's even a section on the question of social media companies and what their kind of content moderation consists in, why it's a challenging activity on their part, why it is and should be protected by the First Amendment. And I'll then also mention a second resource. It's a previous podcast that I did with Steve Simpson, who is with the Pacific Legal Foundation, also a former ARI legal fellow. Steve joined us for a conversation on "Does social media censor?", where we dig even further into that particular question about whether what social media companies are doing is censorship, why it isn't, why we need to be very clear in understanding the meaning and definition of our concepts on this very crucial legal question. Paul, were there any resources you would want to share with the audience, briefs or anything like that NetChoice has put out that might be especially good for them to look at?
Yeah, if you're at all interested in these cases or other cases dealing with internet free speech, you can go to netchoice.org/litigation. There we have all of our briefs and the briefs from the states available for free that you can go read, download to your heart's content. If you have questions for NetChoice specifically about any of our cases, we're happy to answer them. Just email press@netchoice.org. Otherwise, thanks, Ben. This has been a really great conversation.
Yeah, really great to have you on. Really great to especially see former ARI affiliates going on to do big things in the world, as at levels as high as the Supreme Court. So, and again, I mean, I hope we have you back again to talk more about this.
Yeah, I'm happy to come back to talk about this or any of our other cases if they pique your interest.
Okay. Thanks very much, Paul. If you enjoyed watching today's program, please be sure, if you're watching on YouTube, to exercise your online free speech rights to help craft their algorithm, both in your favor and in ours, by subscribing to our channel, by clicking that bell button to get notifications from when we post new content, when we go live. If you're watching a recording, continue to exercise that online free speech right by leaving a comment, hopefully in accord with the company's community standards. Like it, share it, tell your friends about it. Do the same thing if you're watching, please, on Facebook Live. And if you have any questions about what came up in the conversation today, please send us an email to newideal@aynrand.org. We read everything that comes in. We try to respond to most of it. Sometimes we do episodes based on what people suggest. Thanks again for this conversation, Paul. I hope we see you again.